my name's still Aaron Powers, and I'm still the co-founder and CEO of Hunit. And this is the next video in our overview to smart legal contract use under English law. The previous two videos, first one dealt with some foundational concepts around the technology being used. The second, talking about what's happening in this space and what are smart legal contracts. And now this third module is about using client services under English law. And I guess bottom line is, we find that the general perception is that this is a little bit like fusion. In power generation, it's always going to be a few years away. This is actually a lot more ready than you think. Sorry, but we have to do this every time. The guidance provided in this video is Hunit's and Hunit's alone. It's not binding on any of the parties, such as courts or the Solicitors Regulation Authority. Additionally, the guidance is for discussion purposes only, meaning that if you are seriously considering using smart legal contract technology, please seek independent advice. Now, we touched upon in our last video the Law Commission and the work that they did in their guidance to government around what smart legal contracts are and what they aren't. And the basic takeaway from first their public consultation and then the publication of guidance to government was that smart legal contract technology is fully compatible with English law as it stands today, but with caveats. And so what were those caveats? Number one, formation. Does the smart legal contract provide all of the constituent elements needed to create a legally binding contract? And here, natural language-based agreements or smart legal contracts do have a bit of a structural advantage over code ones. But and this, I think, was largely born out of analysis of smart contract technology, which is not smart legal contract technology, as addressed in some previous videos. But essentially, we need to make sure that the parties clearly intend to make an agreement. There has been a consideration for that agreement, that there is certainty and completeness around the structure of that agreement. They have shown an intention to create legal relations and to complicate these things with a formality. So smart legal contracts need to make sure, again, you can do a lot with a technology platform, but best practices by the solicitor is going to be a critical part of compliance for this space. Second is interpretation. One of the questions they asked was, how will a court, or in this case, an alternative dispute resolution, a platform, use the contract to understand the intentions of the parties? I think one of the problems that we have with smart contract technology is that they capture the agreed mechanics of a relationship, but not the intentions, or rarely do they capture the intention of the relationship. And a court adjudication or an ADR adjudication is based on comparing what happened, in fact, versus the intention of the parties. And if there's no record of the intention, or it's difficult to interpret the intention of the parties, then a court adjudication becomes a challenge. Third concern that they have to do with remedies. How can an SLC be paused or rectified or otherwise remedied once it enters into force? So this is basically, a court has a guaranteed right to be able to interrupt the execution of any legal agreement that it sees fit to interrupt, and to rectify it, to change that agreement. Additionally, how do counterparties into an agreement decide to change things? The fatalistic nature of smart contract execution challenges that. So the Law Commission said, this is an area of concern of theirs, but it can be addressed. Consumer protection. We believe, and probably sooner than many will believe, that smart legal contracts will be used up and down the value chain. So this will not be a technology that's only being used at enterprise level. This is not a technology that will only be used in alternative assets, but they will be used for your car lease. They will be used for your mobile phone subscription. How does a consumer freely understand the terms of a smart legal contract unless it is recorded in the language that is clear to them and that the automation is made clear to them? This is an area that is critical for the compliant use of smart legal contracts. And finally, jurisdiction. I think this is one that is more related to cryptocurrencies than anything else. If a smart legal contract does not specify jurisdiction, how is a court going to determine one based off of the center of activity related to that smart legal contract? And so this is really, I think, more relevant if you have the center of activity is a distributed ledger network that is running on a global basis. So how do you determine where Bitcoin occurs when it occurs a little bit everywhere? So again, as if these other ones, best practices does matter. As in a normal analog agreement, fail to specify jurisdiction at the peril of you and your client. So this is another area of investigation. So when we prepared this publication that we referenced at the end of our last video with the Law Tech Delivery Panel, we worked quite closely with the Solicitors Regulation Authority, the SRA. As a whole, this may sound unusual to many solicitors if you're watching, but they have been a fantastic, constructive partner in trying to understand the space. But I must point out that the discussion points here that we're providing around what our guidance is our guidance alone. Even if we did work closely with the SRA and have taken their considerations into effect, it is not, the guidance that we're providing here is not binding upon them. This is our opinion alone. So 3 parts to the investigation that we did with their support. Number 1 is how are smart legal contract automated payments viewed vis-a-vis current regulations with regards to use of client funds or client trust accounts. A significant value driver for smart legal contracts is their ability to receive and forward cash, so basically to mediate payments pursuant to a legal obligation. But if the SRA, under its accounts rules, finds that is a challenging value proposition for automation, then clearly smart legal contracts are going to have a hole in what they can, in terms of the value they can deliver to the market. So we know under the SAR, or the SRA accounts rules, that client monies must be held and handled in accordance with the SRA. So there's 2 types of use of client accounts, and I think it's important to differentiate. One would be the advance payment of fees, which is a little bit to the side of the discussion today, but secondly, client accounts are often used, for example, to receive proceeds of litigation or to collate an equity issuance, or subscription for shares from a number of investors into a private company, for example. Often the firm will use their client account. How can that be replaced by a smart legal contract? So paragraph 2.3 of the SAR allows for the use of what are known as third-party managed accounts. So this is a relatively recent development. Just a few years ago did they allow for these types of things. So this allows for an external service provider to come in and provide a client, basically provide an alternative to a client account. The nice thing about these things is that once you can technify this, you start to have a significant reduction in risk. For many solicitors, well, if you look at the number of solicitors being struck off by the SRA, by and large, not all of these are unintentional, of course, but by and large, the largest category of grounds for being struck off is abuse of client funds. And so how this type of technology allows for the reduction of risk inside of a firm, and also reduces the amount of manual processes that they need to follow. Now, paragraph 3.3 of the SAR disallows use of client services of any type, for example, or client accounts of any type, for funds that are inadequately linked to link to a regulated service. So even if there are many types of payments underneath a legal agreement that are related to regulated services, there are many types that are not. Right? So how does a smart legal contract bridge both of these sides safely, so that in either situation, a smart legal contract can provide payment-related services to its participants? So essentially, our insight is that the smart legal contract and its automated payment facilities can provide both categories of payments as long as it is simultaneously registered as a TPMA, or third-party managed account provider, as well as an authorized payment institution under FCA, or Financial Conduct Authority regulations. So this lays the foundation for smart legal contracts to be used in the types of transactions we've talked about in some of the previous slides. Part 2 of our investigation is what are some additional considerations for solicitors seeking to use smart legal contract technology. What else do they need to think about other than just simply payment? So, and again, these are essentially updated views on the regulations as they already exist around regulated services. So, number 1, they need to act in their client's best interest, and they must provide a competent service. Right? It's non-controversial. So what does that mean in this case? It means, is a smart legal contract right for the client in the application? Does the solicitor clearly understand how they're going to function? And does the solicitor take that clarity and provide it to the client as well? Do they understand when and where the automation will proceed and what it costs them to have that automation proceed. Presume that the firm will be accountable for the service provided for the smart legal contract. So the obligation does not end with the delivery of the smart legal contract, but it ends with the conclusion of its life cycle. Insurance. So, and here as a service provider, we have some plans in the work for how to solve this in a more systematic level. But essentially, any firm needs to make sure that they are essentially properly insured for the use of smart legal contract technology inside of regulated client services. Money laundering regulations, AML, KYC, smart legal contracts do not relieve the firm of their obligations. They may provide technological tools that make compliance easier and cheaper for the firm, but the firm still needs to have a very watchful eye on here. They cannot wholesale outsource this to a platform. Client confidentiality. Smart legal contract use has the potential to share client information outside of, well, in a way that require informed consent. And so that will depend on the use case, that will depend on the platform. We clearly are being very careful of this as a service provider ourselves. But so when it comes back to does the solicitor understand them, the solicitor needs to understand how client information will be shared inside of a technified contracting environment, and if needed, get informed consent from the client for that use. Court remedies. So if a smart legal contract or its platform disallows court remedies in certain situations, maybe desirable, maybe not, the solicitor must be satisfied that it is not contrary to English law. So this comes back a lot to best practices. We have some guidance around those as well for later. So the key takeaway is that smart legal contract technology, as much as we would love to say this is something that's never been seen before, it is technology, it is legal tech, and it is regulatable underneath existing rules. So think of it in that context. Part 3 of our investigation with the SRA has been around costs. And this is a really interesting area. So I mentioned in our previous video that we did something that we called the listening tour. And this was basically a series of customer focus groups that we did with law firms and in-house counsel in 6 different countries. One of the things we found in those interviews is that there is a lot of a focus on billing model evolution. And so right now, people are broadly questioning, is the multiplication of rate by time the best way to express value inside of a legal services relationship? And we're seeing that there's experimentation around this question. One being the use of subscription services, another being project-based services. Can SLC automation be a source of ongoing revenue to the firm? Meaning, can the automation itself trigger value capture to the firm? A firm could decide to bill their clients in a very traditional way for the creation of a smart legal contract. Right? We spent X number of hours to create this for you, here you go. Or smart legal contracts and their ability to capture value as they create it over time could mean that a firm could experiment with a model where they essentially give away the smart legal contract itself and instead create revenue for the firm as it executes. And the implications of that on the firm, and this is a broader area of discussion, quite fun, which is, for people that are, intent to become partner, right now the paradigm is long hours all the time. In an environment like this, a really cleverly built smart legal contract can create value and revenue for the firm for many years, even after the active authoring period has ended. So, what we believe is that there are no impediments under the account rules or otherwise inside the SRA's regulatory texts that impede client or firms from charging their clients for SLC technology-related costs. But, and here's the but, solicitors must be clear and transparent about the nature of these costs, and they need to be very clear to the client around how the automation works, when it will work, and how the automation will trigger those costs for them. So it is clear that they need to understand this in advance. So and this is what I just talked about a second ago, the SLC, I'm a bit ahead of my slide, they represent a potential path to disassociate client revenues from time work. So it's a very exciting development, I think, generally inside the space. So bottom line though is transparency, clarity, and defendable use of cost-generating automation is key. I think they're amongst people with say variable moral compasses, I'm sure the temptation will be there to put a lot more automation in there than is needed. These are the things that need to be minded. We have created some initial best practices for regulated service providers to consider. One is client transparency. I think this has already been clear on the previous slides. Very important that you communicate clearly to your clients around smart legal contract technology. Secondly, this is having to do with reserved activities. And this is actually a bigger issue, I think, that's touching upon a number of different sectors right now, whether it's self-driving cars, whether it is algorithmic trading inside of the financial services space. The question is, you know, if you believe the press releases, the only reason why we don't have fully self-driving cars is because we haven't yet figured out how to apportion blame in the event of an accident. And I think same thing here with reserved activities, if you want to make that analogy. Is automation attempting to automate reserved legal activities? And so the question there around best practices is, if so, is it allowable under the Legal Services Act of 2007? So the SLC author should consider the use of human review and approval steps inside the execution of certain types of automation. It's critical that an authorized service provider hits a approve button, for example, in certain types of automation. As a corollary to that, essentially authorized persons. So in the event you have an approved button, and we'll get back to the use of smart legal contracts and their interaction with human beings in a second, but anyone that's providing that human review step needs to either be an authorized person or fall into an exemption as identified in Schedule 3 of the Legal Services Act of 2007. So this is, when it comes to who is hitting that approval button, the person must be authorized to have performed that task outside of the automation, should no automation have been present. Digital boilerplate, here this comes back to consistency, again, very much around best practices for drafting agreements. Consistent use of boilerplate clauses is required for creation of smart legal contract that is compliant with law. For example, always making sure that a rectification clause is present that allows for the parties and or court to pause and amend an agreement, something that should be part of every single smart legal contract that's being signed into effect. And then finding underlying structures, and this is interesting because this has nothing to do with smart legal contracts in a way, but then also everything, which is if you're using a smart legal contract in such a way as to, for example, trigger a remedy in the event of a certain type of breach, then the steps being described in that remedy need to be actionable by the smart legal contract in a way that cannot be contested or blocked by a recalcitrant party. So the question here to ask is, are the underlying legal structures, right? Special purpose vehicles, equity transfers, all these things, in terms of the mechanisms that a smart legal contract provide, are the underlying structures being arranged in such a way as to provide a certain outcome by the smart legal contract? Because I think it would be a poor outcome for the counterparty of a smart legal contract to expect it to be able to do something, but then find out that no, in fact, an unhappy counterparty can block that with an injunction and undermine what was the intention of the parties at the outset. Now, this will get a little bit. This is explored in full detail in the document that we provide a link to and have talked about in the previous video. But this is an example smart legal contract-based escrow agreement. And a key takeaway: if smart contracts in that space have been very much around the complete elimination of the human factor in a transaction, right, which is a requirement if you're going to be transacting anonymously. Interaction with humans is critical to smart legal contracts. Now, they do not, in fact, eliminate the use of humans, but maximize their efficiency. So, for example, we'll get to how the escrow agreement would use human input. Because the bottom line is, as much as we would like to think that machine learning and AI has really gotten to the point where, well, it can beat us at chess, but it is indispensable when it comes to understanding novel situations. I guess that more or less the same point twice. So it's critical that, and it also complies with how law is being functioning today, either in court or in the execution of certain types of agreement clauses. So it's important to understand that when things have to do with subjective measurements you can provide automation around a subjective measurement. The critical part here is essentially to use a governance function or a polling function inside of a smart legal contract that will ask designated parties and or groups of designated parties whether or not those subjective terms have been met inside of an agreement. So how that would work in the case of a smart legal contract used for escrow is that a human would be asked to verify that the conditions precedent for the transfer of the escrowed sum has been satisfied. And that can be, those conditions precedent can be things that fall far outside of what would be technologically verifiable. Here, we're actually using, our example escrow agreement is for the sale of a marine vessel, of a merchant marine vessel. And so typically you have all sorts of inspections, right? Were there actual physical faults to the vessel? There is no smart legal contract, that is capable of verifying those steps currently. Have the buyer and the seller mutually agreed to waive conditions precedent? This happens sometimes. They decide that, well, they're gonna, even if certain things have not been fulfilled, they'd like to complete the transaction anyway. So here again, using a smart legal contracts mechanism to create structured data out of interaction with people, you're able to have that agreement proceed even with waivers in place. But because of that waiver, let's say one of the things that it didn't pass was something related to its inspection, but because of that, they decided to amend the final sales price. Again, a smart legal contract can handle this level of variability, but it relies upon people to do so. If there's been a dispute around this transaction, that dispute can play out in any number of jurisdictions, let's say. So let's say it ends up being adjudicated by an alternative dispute resolution group in Singapore using English law. Well, even if this was decided between an English and a Norwegian company and it gets litigated in Singapore, the escrow agent, because of that intellectual flexibility, is able to understand when final adjudication has been provided, even if that final adjudication comes in the form of an analog PDF, a scan of a document that's been signed by a mediator or arbitrator. And then finally, the agreement allows a buyer or seller to assign their interest to a third party, again, upon approval of their counterparty. So, and this is, I think, number 6 is important for any smart legal contract. Is the smart legal contract executing its terms incorrectly? Has the embedded automation been misconfigured in some manner? Well, then the parties are able to identify that and rectify that agreement before it has caused any meaningful damage. Back to our kind of goodbye slide here. For further reading, we encourage you to take a look at some of these documents. Went through them in more detail in the previous episode, but this is our analysis, kind of a very nuts and bolts approach to smart legal contract use by practicing legal sector in English jurisdiction. And more critically for this video, part 3 of this is a full explanation, including flow charting of all the automation and everything else, of that escrow agreement that we were just using as an example. Thank you.